Maternity benefit. Various complications are there in this. The law was amended, so you have like there is 6 months of full maternity leave now. There are clarifications of the ministry saying that this is to be applicable to various other categories of people other than employees. So there's a big question mark about how to implement it in a remote scenario. How do you deal with it? There was a question of creche facility. There's a question of reabsorption into work. What it says is that you can reabsorb afterwards after the maternity leave is over as per a mutual arrangement. Okay. Now the thing is that there is a lot of negative aspect about if the person is not reabsorbed back properly. Like suppose you have somebody else who gets seniority, a junior gets promoted above the person, then it becomes a big problem. And 6 months time, lot of things change, right? But the law has this provision which says you can work from home also under a mutual arrangement. Now, there the question becomes that can you then have a different written arrangement post maternity benefit as per the needs of the situation? Okay, that part needs to be properly documented. Otherwise, that can blow up. Okay, your organization can be named for like not doing it right, not administering maternity benefit, having a glass ceiling, having discriminatory policies. So, how do you administer that is going to be very important. Provision of creche, how do you do that properly? Now in remote scenarios it's very different. So how does that work? Okay, like do you give gaps in the middle of the day to somebody who is a mother and who's crossed her 6 months of leave? How does, and after that she's come back, how do you implement it? Maintenance of registers and records, this is there under each and every law, right? Then provision of data and responding to labor authorities is a very important question. Breach of confidentiality, non-compete and non-solicit. I have dealt with this earlier, but that was just like a general thing to look at the time of exit. Now I'm talking about what actual breaches you will have to deal with if it happens. At the time of full and final, you did that. At the time of employment agreement or consultancy agreement, you wrote this, right? Now, what are the breaches where you'll have to get up and act? Right, so company information being shared with competitors, lot of times existing employees will do that. So you have to get the information about it, and you may not have direct evidence, you will have indirect evidence where you will have to act on it, right? So you will take action under two things. You can take action, okay? Two different actions are possible. One is under the code of conduct and one is directly before a court. Okay, code of conduct will be disciplinary proceedings. The other is directly before a court for breach of contract. Okay, so these are two different things. If you do it in internally for disciplinary proceedings, you will lead to at the end termination. If you go before the court, there what you will ask for monetary compensation for the loss caused. Okay, leaked out to the press. Here, what will you do? Again, you can do a disciplinary proceeding and terminate, but you want compensation, you may need to go to court. Okay. Employee joining a competitor. What do you want to do here? How do you stop an employee from joining a competitor? First, you have to check if your non-compete clause is reasonably narrow. It has to be super narrow. Okay. It cannot be very wide. Otherwise, the court will say this non-compete is nonsense. Now I'll give you an example. Even in Infosys's case, okay, there's a contract that was filed with the BSE. Okay, they clearly wrote, and it was their CEO or CFO's contract. They clearly wrote that if you leave Infosys, you will not join these five companies. They named five companies: Wipro, I think they named Cognizant, like that. Okay, so they said these five companies you won't join. Everyone else is fine. So non-compete is very the hardest clause to enforce. That's why what people do is they name companies to keep it very, very narrow. Employee or consultant taking away your customers after leaving, okay, for his or her own business or her new employer, even if it's not competing. Now, HR manager will need to follow this up with a notice. You can say, okay, company legal team has to do it. I'll not do it. What is the point? But what if you did this? Will it help? Because as the HR, if it's coming from you, more people will comply. They will know HR will enforce this against us. You are closer to the line of action than the legal team. Okay, employee leaving with his or her colleagues. So here, what's the issue? Which clause of the employment contract is violated? If the employee leaves with his or her colleagues, non-solicit is violated there. Okay, NS. Consultant starting a competing business after working with your company for a long time. You can have non-solicit also, you can have confidentiality also being violated. You have to tell the legal team that this is the information I have. You have to send this notice. I have given you the first draft. You can review it and send it out. Okay. Or you can say that I will sign it out, put the authorized signatory signature, and I will send it out myself. Disciplinary proceedings, termination, and discharge. This is the hardest part and is loaded with lots of legal complexities. Like discharge on medical grounds is relieving based on medical issue, right? But conduct of disciplinary proceeding. So this is not a termination. This is not a disciplinary proceeding aspect. This is not a performance aspect. This is about being free, fit for work for that job. So you have to do the discharge on medical grounds in a way that it is not putting stigma on the employee. Okay, otherwise others won't hire the employee, and the employee will go to court saying that you are you know uh, you've dismissed me, whereas what you were supposed to do was just let me exit from my job. Now it looks like a firing, so you're not firing at that time. Conduct of disciplinary proceedings itself, there are parts like inquiry, hearing, writing the orders, and various orders. Like there's initial, you'll have to write to the person who's accused. Then you'll have to write uh, summons, you'll have to write order, daily order, final order, all of that, report. Discharge letters. What's the difference between dismissal and discharge? Discharge is just relieving for job, from job. Nothing to do, no adverse effect. Okay, discharge doesn't mean there's a non-performance. Discharge doesn't mean there is a misbehavior. Okay, discharge is just relieving for job for whatever reason. Okay, termination for lack of performance is different. Termination for misconduct is different. Here you need to do disciplinary proceedings. A lot of times HR managers are confused that which is the correct thing to do and how to take action for each of these. For each of these, like medical grounds, non-performance, non-confirmation of probationer, all of these are different. Misconduct, your action has to be different. Dismissal for unauthorized absenteeism also is going to be different. You can't do a hearing in this one, because the person has been absent. If the person comes, great, but if they don't come, then what will you do? How will you hear the other side? There's a technical requirement in law that you have to observe natural justice when you conduct disciplinary proceedings. This is one kind of disciplinary proceeding where you cannot fully administer it, and there is an exception because the person won't turn up, he's just vanished, right? So you have to use it properly, but you have to document that. Otherwise, the person will say, I was coming. Okay. And they will say that your attendance machinery was faulty, didn't record my absence, or the HR used to manually tamper it. So you don't want to have all that. Then there is another provision. You can see this in factories, especially it is there in Standing Orders Act. Before the inquiry is being, when the inquiry is being conducted, no, you can suspend the person. Two kinds of suspension is there. Pending inquiry, meaning we are conducting the inquiry, so we don't want you to talk to all the employees and witnesses and tell them that, tell them to report in your favor. So you have to basically suspend the person so that they don't come to workplace. Now, at that time, you have to pay a subsistence allowance. There can be another kind of suspension which is as a punishment. The two have to be differently administered. Okay, the allowance will be different, the duration of those suspension will be different, and you have to keep it in line with the law, because you can't violate minimum wages, you cannot violate the subsistence allowance angle. Okay, payment of subsistence allowance is important.